Hello, everyone. We're just giving it, I believe, 2 more minutes, just to ensure we have space to let everyone in.
Okay. Okay, I've gotten the green light to go ahead. First, I want to say a few words in Arabic for our Arabic followers. تحياتي لجميع المستمعين باللغة العربية. هذه الندوة ستتم باللغة الإنجليزية بس في ترجمة فورية في العربي. ممكن تسمعوا اللغة العربية إذا بتضغطوا على الايكون شكل الكرة الأرضية تحت الشاشة، واضغطوا على اللغة العربية، وبتقدروا تسألوا الأسئلة بالعربي والمترجمين بترجموها. للي بيسمعوا من خلال اليوتيوب رايحين تسمعوها بس باللغة الإنجليزية. بس كمان راح يكون في تسجيل لهذه الندوة، بنحط على موقع Law for Palestine من هون لآخر الأسبوع. شكرا لكم. Back to English. Greetings, everyone from Ramallah. A warm welcome to everyone joining via Zoom, as well as members of Jurists for Palestine Forum and those watching via the live broadcast wherever you are in the world today. Also, a special thank you to Law for Palestine, the ETO Consortium, and the Palestinian Independent Commission for Human Rights. My name is Wissam Ahmed, the head of the Center for Applied International Law at Al-Haq, the first Palestinian human rights organization, where I've had the privilege to work since 2006, very long time, but it's been a very challenging experience, especially over the last few years for all of us. As I have a particular interest in the area of business and human rights and the role of corporate actors and the economic incentive structure perpetuating the colonization of Palestine along business lines, it's an honor to be moderating this webinar with such a distinguished panel of experts. Now, the recent ICJ Advisory Opinion and the UN General Assembly resolution highlighted the legal obligations of states to act against Israel's unlawful occupation of Palestine. With regard to economic considerations arising from the legal consequences of other states, in paragraph 278 of the advisory opinion, the court considered the duty of distinguishing dealings with Israel between its own territory and the occupied Palestinian territory, encompassing inter alia the obligation to abstain from treaty relations with Israel in all cases in which it purports to act on behalf of the occupied Palestinian territory or a part thereof on matters concerning the occupied Palestinian territory, to abstain from entering into economic or trade dealings with Israel concerning the occupied Palestinian territory or parts thereof which may entrench its unlawful presence in the territory, to abstain in the establishment and maintenance of diplomatic missions in Israel from any recognition of its illegal presence in the occupied Palestinian territory, and to take steps to prevent trade or investment relations that assist in the maintenance of the illegal situation created by Israel in the occupied Palestinian territory. Now, this is the language of the court, but what does it actually mean? That's what we will try to unpack in the next hour and a half. This webinar will explore general economic state responsibility under international law, ways forward for envisioning measures by the UN General Assembly, state responsibility under international investment law and international trade law, corporate responsibility and anti-boycott measures, and practical steps to implement sanctions and dismantle economic complicity. This discussion will provide actionable insights into addressing these critical issues with input from experts in law, legal practitioners, and academics. Our first panelist is Dr. Shahd Hammori. Shahd is a lecturer in international law and legal theory at the University of Kent. Her research is focused on questions of international law and war economies. She's the author of the forthcoming book, Corporate War, Profiteering and International Law. She's a non-resident fellow at Al-Haq and a senior legal consultant at Law for Palestine. Dr. Hammori's experience includes acting as legal counsel in the ICJ case on the legal consequences of the Israeli occupation, researcher for ECCHR on arms accountability, a consultant for Chatham House on war economies, among other positions. Shahd, I'll give you the floor first to address the general economic state responsibility under international law for 10 minutes. Go ahead.
Thank you so much, Wissam. And indeed, it is an honor to be here with colleagues and comrades. The moment the advisory opinion came out in July last year, we were faced with the question of how is it that we take this forward. The starting thoughts behind this panel came when we wanted to have a reading of this decision that is Palestinian-led, that talks to the ethos of how we envision the future of Palestine, as well as a global South-led reading of the court's decision. Herein, I will provide the primary premise for how we started to think about this collectively and how we can envision this. The argument that I will put forth is quite simple. It is that Palestinian self-determination is inherently decolonization. That is the premise for envisioning the way forward. Though that may seem like a pretty straightforward premise, however, sadly, the world that we live in has worked through colonial erasure, as well as the erasure of the experiences of the global South, in order to deem such a logical conclusion actually quite absent. And I will further elaborate how building on this premise and way to envision going forward, we can talk about third state economic responsibility as well as UN General Assembly resolution. So to begin with, the court has given us quite a strong decision in the sense that it has told us that Israel is in violation of at least 3 Jus Cogens norms in international law. And that means preemptory norms of international law, which means that this is the highest level of rules in the international legal system. Why? Because the violation of these rules is inherently an impediment to international peace and security. Herein, Israel is in violation of the prohibition against aggression, the prohibition against racial discrimination and apartheid, as well as the protection of the people's right of self-determination. What do we have when we look at that from a holistic perspective? It is indeed the image that Palestinians have talked about since 1948. It's a typical image of what is called in law alien, domination, and subjugation. Colonization, in short. So once we perceive this case as a case of classic act of colonization, the materiality of what is happening here extends beyond 1967. And the legal premise for that is Israel's violation of the people's right of return. It is important to recall that one of the conditions for the acceptance of the State of Israel in the United Nations was the recognition of the Palestinian right of return. So here we are talking about an accumulated international wrongdoing by not recognizing the people's right of return, adding to that the accumulated wrongdoing of not paying reparations, adding to that, of course, the apartheid system that Israel has instilled against Palestinians within its own borders. Herein, we understand the colonization as inhabiting the whole of what is known as historic Palestine. So My premise here finds support in both the separate opinions of Judges Iksu and Judge Youssef, who perceive of Palestinian self-determination as decolonization, seeking to envision it on that premises. Meanwhile, it is very well known that the envisioning of the right of self-determination in international legal scholarship is indeed limited, to say the least. There is a poverty in our imagination of the right of self-determination. And why is that? It is because of the erasure of the experiences of states of the global south. It is simply because these stories are not told. To think that statehood or democratic or institutional democracy are the end goal of self-determination in a context of colonization is false. In short, the experience of post-colonial states have shown us that claiming independence honestly close to means nothing. Indeed, this Western-led imagination of the right of self-determination has led states of the global South to be stuck in what can only be called a perpetual process, rather than reaching the substance of self-determination. Herein, if we look at founding documents such as the Algiers Charter, we find that the right of self-determination is inherently premised on non-exploitation, non-domination, as well as the right of return. To establish a legal and institutional system that enshrines within its constitutional values not to dominate these people and also not to economically exploit them. That is indeed the lesson learned from the experiences of the global south. Herein, to speak about Palestine, the relevant precedents are Angola, South Africa, Namibia, Zimbabwe, Algeria. We need a harmonized reading of international law, which gives value to prior General Assembly resolutions. As recalled by Mohammed Bijawi, UN General Assembly resolutions are an important space for the expression of positions of states of the Global South. Actually, a critical reading of it tries to give more weight to UN General Assembly resolutions in international legal making. So here I move on to the more solid question. What are the questions that we need to ask in order to envision third state responsibility once we establish Palestinian self-determination as decolonization? So as noted by Wissam, the first layer that the court has told us about, which is to suspend all economic activity where Israel purports to be acting on behalf of the occupied Palestinian territories. How can we take this forward? So some would like to only limit that to economic activity that has to do with the settlements. That is indeed the most reductive and harmful reading that one could have. We're not talking only about the settlements here. And actually, as an economic exercise, it is almost impossible to differentiate between the Palestinian economy and the Israeli economy due to their codependence. And we will be publishing soon a study to that end. So and also there is a lack of information as to how each of the economies are connected. This is, again, a very typical case of dependency. I will go faster, of dependency in the context of colonization. It is impossible to disentangle the two economies. Herein, if we are to only follow that as our way forward, we would be stuck in institutional mediocrity, not what is needed for such a context of extremity. Another way to look at it is to look at the second layer pushed forth by the court, where it said that states need to undertake efforts to prevent trade or investment relations that assist the maintenance of the illegal situation created by Israel in the occupied Palestinian territory. So what do we mean by such acts? So here, what I'm proposing is the way forward is to start by the question of what is the purpose of third state responsibility here? Ending colonization and protecting the Palestinian people. Herein, the main way forward is by economic restrictions on the perpetuating states. And here I recall the wording of UN General Assembly resolution in 1982, where it talked about Israel and said that states have the duty to cease forthwith, individually and collectively, all dealings with Israel in order to isolate it in all fields. Which means, going forward, and here I am quoting the General Assembly, deploring any political, economic, military, technology support to Israel that encourages Israel in committing acts of aggression and perpetuating its economy. So, away from only the duty to prevent genocide, based on this reading, we have a way to assert that third states have a duty to impose a three-way arms embargo on Israel, energy embargo on Israel, focusing on the technology industry, finance industry, and starting with the question of what leverage does each state have towards stopping or isolating the Israeli war economy. And that is the only way forward. On that note, I thank you all for listening, and I look forward to hearing the following contributions.
Thank you very much, Shahd. I hope didn't interject too much, but I'll try to keep everyone to time, just so we have enough time for questions from the audience. Our next panelist is Dr. Kinda Mohamadieh. Kinda is a senior researcher and legal advisor with Third World Network Office in Geneva, where her work focuses on WTO negotiations and issues pertaining to international investment governance and legal accountability of business enterprises. Kinda, I'll give you the floor to address the area of state responsibility under international trade law for the next 10 minutes. Go ahead.
Thanks, Wissam, and thanks for the organizers for inviting me to this important exchange. So in light of the ICJ Advisory Opinion, we wanted to look at the legal framework that would be applicable to trade measures by third states in relation to Israel. And our work clearly points towards two results that we can come to. One is that comprehensive trade measures against Israel are not only permitted, but are required in order for third states to fulfill their obligations under international law, following from the ICJ Advisory Opinion that confirmed Israel's overall presence in the occupied Palestinian territory as unlawful, including because of the frustration of the Palestinian people's right to self-determination. The second point we come to is that trade law provides the legal basis to undertake such comprehensive trade measures while remaining compliant with the general obligations under WTO law. So in this light, states are compelled to act individually and collectively, such as under the umbrella of the WTO and under other relevant regional and international organizations where they participate as member states. And to unpack this, I would like to speak to three issues. One, the basis for third states' legal obligations. Second, what WTO law specifically provides for. And third, the scope of trade measures that also Shahd started to tackle. In regards to third state obligations, given the ICJ's affirmation that Israel is breaching peremptory norms of international law and the ICJ's emphasis on the erga omnes character of the breached obligations, the legal framework supporting third states' actions, including in relation to trade, rests on two primary pillars under the law of states' international responsibility. Basically, here we need to be looking at Articles 40 and 41 of the Articles on Responsibility of States for Internationally Wrongful Acts. And here we have two considerations. One, that states have a positive obligation to cooperate to end the serious breaches of peremptory norms. And this obligation applies to states whether or not they are individually affected. And the second important thing is that there is no specification of the form of this cooperation. So it could occur under the UN or other arrangements, including ad hoc arrangements by groups of states. And in the context of trade, we would see that the action under the WTO is an important step that states should consider. Now, when it comes to the obligation not to recognize as lawful a situation, the situation created by the breach, and not to aid and assist in maintaining the situation, which is the second pillar for the third state's obligation, this extends beyond aiding and assisting in committing the serious breach. It is about maintaining the situation resulting from the breach. And in the previous practice, such as in relation to apartheid, the UN General Assembly was clear in affirming that continued trade relations with the state committing the grave violations would assist this state in defying the world opinion, in aggravating the danger of violent conflict, and in nullifying the efforts of the UN to solve the problem. So in this context, we see that this obligation provides a basis for states to legitimately avoid all types of normalized international cooperation with Israel. Now, trade measures, as mentioned, have been covered under the General Assembly resolution of September 2024, which basically have translated the ICJ opinion into practical actions, or what the ICJ referred to as precise modalities required to end the illegality of Israel, but also were covered under the opinions of the UN human rights experts and the opinion of the UN Independent International Commission of Inquiry that came after the ICJ Advisory Opinion. And it's important here to underline that the way the General Assembly resolution and the UN experts and the Commission, the Commission of Inquiry approached this, they indicated that the economic relations concerned here should include relations that could pose a risk of contributing to the unlawful presence and to pose a risk of contributing to the maintenance of the unlawful situation. And they definitely indicated that these economic relations we're talking about go beyond the dealings with the illegal settlements. Now, what does WTO law say? WTO law already incorporates bases allowing states to take such exceptional trade measures, particularly if we look at Article 21C under the General Agreement on Tariffs and Trade, which is also replicated under other WTO agreements. It provides an exception allowing states to undertake measures to pursue their obligations under the United Nations Charter for the maintenance of peace and security. And so basically it allows them to pursue measures despite these measures being unlawful in normal circumstances. So, and here just to indicate that most third states' trade relations with Israel are governed by WTO rules. Some might have additional free trade agreements or other arrangements, but these would be additional to what is provided under WTO law. And most of free trade agreements would replicate the exceptions that I will be discussing today. So basically, this exception under WTO law is a realization already incorporated in the architecture of WTO rules that sets a hierarchy between states' obligations under the UN Charter and those under WTO law. And very particular to 21C is its wording. It sets a broad rather than a strict correlation between the measure taken and the set objective. So it does not require, unlike other parts of this exception, a necessity test, for example. And thus, we would argue that it would allow states to undertake broad trade measures in pursuance of fulfilling their obligations arising from or in the context or as a result of Israel's illegality. And in the history of practice under the GATT, basically preceding the establishment of the WTO, this exception, which existed at that time, was already used in relation to implementation of UN resolutions. The last issue I want to address is giving additional justifications to what Shahd addressed to why we need to be talking about comprehensive measures rather than measures focused on the illegal settlements. One point is arising from the systemic nature of Israel's prolonged violations. The ICJ Advisory Opinion was clear that the illegality rests with the regime giving rise to Israel's violation, and that Israel's policies and practices, which span decades, include but are not limited to the settlements. So in this context, the scope of the obligation not to assist in maintaining the illegal presence of Israel is broader than the mere assistance in maintaining the settlements. The other point that we need to consider is the entrenched integration of the Israeli economy with the occupied Palestinian territory. And here there's a lot that could be said. One is that the role of Israel as an occupying power cannot be understood as an act isolated from the overall operations of the Israeli state and the Israeli economy. Also, that Israel's practices and policies and laws overall create the conditions for facilitating the exploitation of the Palestinian economy, which in turn benefits this exploitation of the Palestinian economy in turn benefits the overall broader Israeli economy. And it's very interesting, in 2022, UNCTAD released a report that studied how the Israeli economy benefits from Israel's role as an occupying power, and as such from the resources it extracts from the occupied Palestinian territory and the Palestinian people. And in addition to that, the illegal settlements, I will close. In addition to that, the illegal settlements are in permanent state of expansion. So their boundaries in relation to the rest of the occupied Palestinian territory is not static, which basically undermines the attempts to organize business relations, including trade and investment relations, in a way that respects the obligation to differentiate between the dealings with Israel and the dealings with the occupied Palestinian territory. So there's a lot that could be said. Maybe we will address this more in the discussion, and thanks for your attention.
Thank you very much, Kinda. Our next panelist is Lara Elborno. Lara is an international lawyer licensed to practice in Illinois and Paris. She has over 10 years of experience working as counsel in international arbitrations. Her practice covers both international commercial and investment arbitration matters. She has served as an administrative secretary to several arbitral tribunals. Lara has represented clients before the Paris Court of Appeal in proceedings seeking enforcement of exit awards, arbitral awards before U.S. federal courts in proceedings seeking enforcement of exit awards. Lara is passionate about pro bono and oversees a clinic in Paris representing clients at the first instance asylum jurisdiction in France. She's also supported pro bono clients in areas of international human rights law, international humanitarian law, and whistleblower rights, to name a few. Lara's presentation will focus on the consequences of implementing the advisory opinion on Israel's international investment law framework, primarily bilateral investment treaties. Lara, the floor is yours for the next 10 minutes. Go ahead.
Thank you very much, Wissam, and thank you to Law for Palestine for the invitation to participate in this panel. So today I'll be speaking about how states' implementation of the advisory opinion may affect the international investment law framework, in particular, Israel's bilateral investment treaties and other treaties with investment provisions, which Israel has concluded with third states. So the first question is, what should happen to Israel's bilateral investment treaties? I'll be referring to them as BITs in this presentation, if anything at all. So based on the publicly available information on UNCTAD's website, it appears that Israel maintains a total of 36 BITs and 9 other treaties with investment provisions, which are in force. For example, Israel has concluded BITs with the Philippines, UAE, Japan, Azerbaijan, Guatemala, Serbia, Armenia, Cyprus, Turkey, Albania, Kazakhstan, and China. For those who may not be familiar with these types of agreements, essentially they're treaties which aim to encourage and protect investments made by investors from one state in the territory of another state. In particular, these treaties contain substantive provisions, ensuring, for example, that such investments would be entitled to fair and equitable treatment and shall not be expropriated. These treaties also contain an investor-state dispute resolution clause, which allow investors from one state to sue the other state for reparations, including restitution and compensation, before an international arbitral tribunal in the event that the state where the investment is made through its acts or omissions breaches the substantive guarantees provided for in the investment treaty. So, for example, under the Israel-Japan BIT, Israel agrees to protect Japanese investments in the territory of Israel, and Japan agrees to protect Israeli investments in Japanese territory. Furthermore, investors from Japan can sue Israel if Israel mistreats Japanese investments in breach of the treaty, and investors from Israel can sue Japan if Japan mistreats Israeli investments in breach of the treaty. If we look back at the ICJ's advisory opinion, we see that the court, when spelling out the legal duties of states as it relates to Israel's unlawful presence in the OPT, decided that states have a duty not to recognize as lawful the existence and continuation of Israel's illegal presence in the OPT. And explaining what that means, the court has enumerated 3 key obligations of states as it concerns economic and investment relations. So the first is an obligation to abstain from treaty relations with Israel, where Israel is acting as though the OPT forms part of its territory. The second is an obligation to abstain from economic dealings with Israel concerning the OPT, which may entrench Israel's unlawful presence in the OPT. And the third is an obligation to take steps to prevent investment relations that assist in the maintenance of the illegal situation created by Israel in the OPT. So what does that mean in practice, and in particular as it concerns Israel's investment treaties? So in analyzing the legal consequences of the advisory opinion's language, Professor Wild prepared a legal opinion at the request of Al-Haq. And in that legal opinion, he put forward the argument that in order to comply with the court's requirements, third states in the EU must adopt a complete reciprocal trade, including arms, finance, investment, scientific, technological, audiovisual, cultural, educational, and sporting embargo against Israel. And he explained that states must prohibit all trade, including in arms, investment, and any other forms of financing, technology transfer, and the provision of charitable support with the Israeli state and Israeli entities, including universities. So Professor Wild's analysis in support of a total embargo on third state relations with Israel is rooted in the factual reality that, as he says, quote, the economic dimensions of the Israeli presence in the OPT are inextricably linked to the Israeli economy generally, meaning that all economic and trade dealings with Israel concern, in one way or another, all parts of the OPT, and all such dealings may entrench the presence. So if we follow Professor Wild's analysis, that would support the conclusion that investment treaties with Israel should be terminated, and that states should take further affirmative steps to ban investment by its nationals and corporations with the Israeli state or Israeli entities. But I'd like to consider just quickly what the practical consequences of a state's termination of its investment treaties with Israel would lead to. And as a general matter, I've identified 3 main consequences. So in the first instance, termination would close the door on claims for compensation by Israeli investors in the territory of states with whom Israel has signed BITs against those states arising out of such states' treatment to their investments. Israeli investors have previously brought a few cases under BITs to sue third states. In some cases, they've been successful and they've received awards for compensation. In some cases, they have not. There are currently a number of pending cases as well. In the event of termination, pending cases would not be affected, but the effect of termination would be to make it such that investments made prior to notification of termination would continue to be protected for typically 10 years under what is called a sunset clause that is contained in many of these BITs. So investors could conceivably continue to bring claims for years to come in any event. The second consequence is that termination would also close the door on possible claims for compensation against Israel by foreign investors with the nationality of one of the states with whom Israel has signed an investment treaty. As far as I know, Israel's never been sued by a foreign investor under its BITs, but this possibility exists because of the existence of the BITs. But I want to focus on a third possible consequence of termination in the time that I have left, and that's that termination would also close the door on possible claims for compensation against Israel by foreign investors with the nationality of one of the states with whom Israel has signed an investment treaty. And this may include Palestinians with such nationalities, arising out of Israel's treatment of the investment in the OPT. Now, you may be wondering here how an investor in the OPT could theoretically sue Israel on the basis of an Israeli BIT. And although I don't believe that this particular scenario has been tested before an arbitral tribunal, we can draw inspiration from a number of cases for compensation that were filed against Russia by Ukrainian investors under the Russia-Ukraine BIT for investments made in Ukrainian territory annexed by Russia, to envisage how similar claims could be brought by claimants with the nationality of one of the states with whom Israel has a BIT against Israel for its acts and omissions against investments in the OPT in violation of BITs. You can, for example, imagine that there may be any number of individuals or entities who've invested in the OPT for the benefit of Palestinians and whose investments were destroyed through Israel's acts and omissions. And I just want to make a point here that the extent to which such a claim will be successful will depend on whether the claimant in that case can overcome the jurisdictional hurdles. In particular, the main one is going to be with respect to the fact that it's made an investment in the territory of Israel. Now, territory is typically defined under these BITs, and in some cases, with the Israeli BITs, it refers to territory over which Israel exercises jurisdiction. So here the argument would be that Israel's BITs should apply to an investment in the OPT because Israel exercises jurisdiction over the OPT, irrespective of whether that jurisdiction is exercised lawfully or not. And when you look at the cases brought under the basis of the Russia and Ukraine BIT, you see that this is the type of analysis that was accepted. So in 2017, we had decisions on jurisdiction in the cases of Belbek v. Russia and Private Bank v. Russia. And in those cases, the tribunals found that the Russia-Ukraine BIT was applicable to territory regarded as illegally occupied by the international community. And I can speak more about this in the question and answer, but really I just want to say here that if we accept that the consequences of termination of Israeli BITs would be to close the doors on claims against Israel, and also third states brought by Israeli investors, one of the additional questions which I think arises to test whether termination may actually be necessary in this case to ensure compliance with the advisory opinion is whether termination would drive foreign investors away from investing in Israel. And the evidence I'm aware of suggests that this may not be the case. So in the literature, the nexus between the existence and the amount of foreign direct investment in a state and the existence of a BIT regime is not well established. In 2009, Carl Savant and Lisa Sachs wrote in their Oxford chapter entitled The Impact of Foreign Direct Investment on BITs that the influence of BITs on FDI is weak, especially in redirecting the share of FDI flowing from or to BIT signatory countries. In fact, there's even data which shows that countries which have terminated BITs, for example, Ecuador, Bolivia, South Africa, Indonesia, and India, in those cases, investment flows from former BIT partner countries were more likely to increase rather than decrease after BIT termination. So whether Israel will suffer from decreased foreign direct investment in connection with eventual termination of its investment treaties, I think is an open question. Moreover, Israel can continue to provide incentives to foreign investors through its national laws to continue to drive FDI as it does. So I want to be clear that I think the inextricability argument that put forward by Professor Wild is compelling, especially as it concerns the economic and trade agreements, when we consider the very broad language used by the court. But I think that with respect to the specific and narrow case of the bilateral investment treaties, given that there's no reason to believe that termination would have impact on driving investment away from Israel, much less driving away investment that assists in the maintenance of the illegal situation created by Israel in the OPT, I think it's possible that termination of Israel's BITs may end up being only symbolic, as opposed to a means for ensuring states' compliance with the advisory opinion, and it may have the unwanted consequence of closing the door to claims by investors in the OPT, including Palestinians, with the nationality of a state with which Israel has a BIT. And I think that's something that is currently unexplored, and we should certainly consider the possibility that these types of claims could be made. So finally, in closing, I'll just say whether or not states decide to apply a total embargo, which includes terminating BITs with Israel, I think there's good reason to consider that termination of other agreements pertaining to trade, arms, energy with Israel should be higher priority for action by states seeking to comply. Thank you.
Thank you very much, Lara. Our fourth panelist, and actually, I want to take just a few seconds to pause for the translators. Okay, hopefully they got a chance to get a sip of water. I'm not sure how many translators we have, but just in case. So our fourth panelist is Dr. Mark Taylor. Mark is an analyst and researcher focused on human rights, illicit financial flows, international crimes, and responsible business. For 2 decades, Mark's research and investigation into war economies and regulatory options for corporate accountability has been the basis for case building, as well as advice to government, civil society, trade unions, and companies. He's also an author of War Economies and International Law. Mark will address economic sanctions as part of state responsibility to dismantle systems of apartheid and occupation, and how anti-boycott laws affect third-party state efforts to impose accountability. Mark, the floor is yours for the next 10 minutes.
Thank you, Wissam, and thanks to Law for Palestine for the invitation, and to my colleagues on the panel for really excellent presentations. My apologies in advance to the translators if I end up speaking too fast, which I almost certainly will. I need to start with a disclaimer because I'm a public servant. I'm an employee of the government here in Norway. I don't do anything in relation to Palestine, but I need to state that nothing I say here is in any way a reflection of government policy or the policy of the agency I work for. It's just me in my private capacity as somebody who's studied and has written on the issue of international legal regulation of war economies. So I'm going to try and do 3 things. One is to sketch outlines of sanctions as an area of law, so that our audience here leaves with a bit of a sense of actually how these things work, how they play out. 2 is to point to the precedent for the use of sanctions, and this really builds very much on the previous presentations, which have laid the legal foundation under international law for why states would be imposing sanctions as a form of enforcement. And 3rd is to try to suggest a strategic approach or a way of thinking strategically about building the case for sanctions against Israel. And I will, if I have time at the end, sort of give a few less well-informed words about anti-boycott legislation. So when we talk about sanctions, what in fact are we talking about? Sanctions are legal measures that impose economic costs on designated targets. And those targets can be countries or entire economies, they can be organizations or networks, and they can be individuals. In the literature on sanctions, what we read is a distinction between old-style comprehensive sanctions that take on entire countries or economies versus targeted sanctions focused on individuals or organizations. We also see a distinction between national or unilateral sanctions and international or multilateral sanctions. So think comprehensive US sanctions against Iran or Cuba versus targeted UN sanctions against ISIS as examples of those 2 extremes. The increasing deployment of sanctions by the EU, especially against Russia as a result of the aggression against Ukraine, really messes with this distinction because unilateral and multilateral, between unilateral and multilateral, because EU sanctions, the EU Council has imposed sanctions that must be implemented by member states. So they're multilateral within the EU, but unilateral in that they're not authorized by the UN Security Council. So Europe is acting as one unilaterally. Look, it's really important to keep in mind that historically sanctions come from 2 different lineages that overlap in the 21st century. The first is as an economic weapon of war. The terms you see used very often in the public debates around sanctions, like siege, blockade, embargo. These are all, economic weapons of war. They're attempts to force an opponent to bend to the will of the attacker, to weaken an opponent through denying resources. So they sit alongside forms of economic warfare, currency manipulations, tariffs, military forms of warfare, targeting economic warfare, so targeting economic resources with the use of force. And it's important in this context to mention that probably the place that has been subjected to the most intensive economic warfare in recent times is, in fact, Gaza since the 1990s, where it imposed closure and then separation and then siege during the first Intifada and second Intifada and since then. So in addition to the lineage of sanctions going back to the notion of economic weapons in war, the last century has also seen a development of sanctions as tools of enforcement. So the use of economic measures as coercion to enforce international norms, and by imposing costs. So or by disrupting the capacity to continue with the violation of international norms. This goes back to the League of Nations. It sits in the UN Charter. And today's sanctions operate as a mixture of this very old economic warfare logic and the more recent enforcement logic. The substance of them can be everything from international peace and security to national security to human rights violations and violations of IHL. In the last 5 years, the most recent development of sanctions has been around issues of global human rights. And the US, the EU, and the UK all have global human rights sanctions that they have implemented, including most recently against Israeli settlers. And I'll come back to that in a second. The most common form of sanctions is an asset freeze. These can be quite specific to a person or an entity, and they can cover literally any economic transaction with that designated person or entity. So the objective of an asset freeze is to effectively isolate the target from global value chains, right? And it can be with comprehensive sanctions to isolate the entire economy of a country from global value chains. There are also, of course, travel bans, bans on entry to countries, arms embargoes, commodity sanctions, and what the US and EU call sectoral sanctions, which they have imposed against Russia, for example, in the energy sector or the finance sector. It should be noted that the US is the single largest sanctioneer globally. I mean, the US leverages its jurisdiction, which it has taken for itself, based both on the size of its economy, but also the role of the US dollar as a reserve currency and a transactional currency. And so they will use US dollar correspondent banks, and they are the most as a form of jurisdiction over transactions that could be happening almost entirely outside of the U.S. But the U.S. is also the most active and powerful enforcer of sanctions by far. UN sanctions are hardly ever enforced by anyone. Okay, so where does that leave us with respect to Israel and Palestine? Well, let's first start with evidence of practice, right? Israeli individuals have been subject to unilateral sanctions. In February 2024, the US and UK imposed targeted sanctions on settlers from the West Bank. And of course, if you've been paying attention to Donald Trump's activities over the past 24 hours since becoming president, he lifted those sanctions against Israeli settlers. I just checked, and they do remain on the UK's sanctions list, so they are still subject to asset freezes in the UK, and that's under the UK's global human rights sanctions regime that I mentioned earlier. I think really interesting in terms of in relation to the context of the presentations that were made previous to mine, UN multilateral sanctions. Oh man, I'm in trouble. UN multilateral sanctions actually begin with an attempt to deal with racial discrimination and apartheid in Rhodesia and South Africa back in the 1960s. And the logic of those sanctions was both apartheid, in the case of South Africa, but it was as a violation of international norms, but it was also South Africa's arms buildup and the potential for it to pose a threat to regional peace and security. Both, I think, very much parallel to the situation we face today for Palestinians within Israel and Israel's role in the region, within Israel and the occupied territories, and Israel's role in the region. I'm going to skip through all of the fun stuff about the development of sanctions, how they developed at the UN, through the UN General Assembly, before getting to the Security Council in the case of South Africa, and just really, what we need to finish with really thinking about what we need to think about when we're thinking about sanctions strategy. So a couple of things that always come up. Do sanctions work? Do they change the behavior of their target? And the answer to that is, frankly, not on their own and not quickly. But they do have effects, both intended and unintended. And those effects need to be thought about in advance in terms of a sanctions strategy. What are they good for? They are particularly good for countries to meet their international law duties with respect to apartheid, genocide, and occupation in Palestine. Why? Because they ensure their own businesses or citizens are not contributing to violations of international law. They ensure that they're not aiding or abetting other states in contributing to doing so. And they ensure that states are doing what they can to prevent violations or to stop ongoing violations by disrupting the supply of weapons or financing to the perpetrators, namely in Israel. Sanctions are very effective at signaling the market as to who not to do business with. So one way to think of sanctions is not as punitive, and certainly not as a substitute for accountability, which many in the human rights community would like to do, but to think about them as a form of regulation. So apply strategies you would normally apply to designing effective regulation. Think about the norms you're trying to defend or advance. Engage at the technocratic level with design of the regulation. And this is something that civil society organizations in the US and in Europe are already doing, engaging with OFAC in the United States, in the Department of Treasury, which manages US sanctions, engaging with the European bodies that are designing European sanctions, trying to get both sanctions regimes brought into play, targeted sanctions regimes, and also trying to get them lifted when it's necessary. And here we're thinking, of course, of the situation in Syria. I don't have time to talk about the anti-boycott laws. I can say a few words about that during questions. I'm not an expert on it, but in general, sanctions are a form of law. And just as we are and we need to think about them as such. They're designed to be technocratic. They're biased in favor of the powerful, but when backed by popular will, they can be useful in constraining the worst manifestations of power. And to the extent that the worst manifestations of power are attempting to use the law back and constrain our ability, we need to be thinking about how we engage in resistance to those anti-boycott laws. That's it for me. Thank you again.
Thank you very much, Mark. And last but not least, our final panelist is Dr. Tara Van Ho. Tara is an associate professor of law and human rights at the University of Essex and co-director of the Essex Business and Human Rights Project. Her research focuses on the impact of business and economic law on human rights, particularly in conflict-affected areas. In 2015, she served as a visiting fellow at Al-Haq, and this summer she will return to the U.S., taking up a post at St. Mary's University in San Antonio, Texas. Tara will talk about corporate responsibility in light of the ICJ decisions on Gaza and occupied Palestine based on the framework of the UN Guiding Principles on Business and Human Rights. Tara, the floor is yours for the next 10 minutes.
Thank you, Wissam, and thank you to Law for Palestine and to Shahd for allowing me to be a part of today's activities. I realize that it is a privilege to be able to share this expertise. I should note that if you saw me furiously writing in my notebook throughout everyone else, that's because I have altered my comments today since Shahd spoke to reflect the vision that she set out. I'm aware that as an American, the last thing a group of Palestinian international lawyers need is for me to come in and tell you what to think. Instead, I view my role here as a means of facilitating knowledge as to how there are inroads in the law to realize your vision. And so that's what I'm going to stick to. I'm going to also try to cover anti-BDS legislation. All I have right now is a bullet point because Mark couldn't. So that will be the last little bit. And if I don't get to it, then we will do Q&A. I'm going to center my comments on the United Nations Guiding Principles on Business and Human Rights, or what I will call the UNGPs. The UNGPs set out sorry, I'm realizing that the translators might need a moment to figure out how to do the acronym for UNGPs. So hopefully that was enough. So the UNGPs set out international standards around how to regulate business activity when it harms human rights and the responsibility of states and businesses when that harm arises, and their responsibility to facilitate reparations for victims. The UNGPs are implemented in a variety of different ways, including through the OECD guidelines on multinational enterprises, which have non-binding arbitral bodies in each of the OECD member states who are responsible for working with businesses and victims to come to a outcome or a positive outcome in reparations for victims where businesses have breached the responsibility to respect. The guiding principles are also being implemented through domestic legislation, most notably, but not exclusively, in Europe. So far, the laws that have been adopted it's an EU law directive, Germany, France, Norway, but you are also seeing development in places like Japan, and potentially in the next few years in Colombia and Kenya and Thailand. So while the guiding principles on their own are not binding on either states or businesses, they do set out a very strong normative claim. We are also seeing them implemented through judicial decision-making in both international and domestic arena. So in the domestic arena, we're seeing a lot of court cases use the UN guiding principles to set out the duty of care that businesses owe when it comes to human rights violations that are committed abroad. We're also seeing them used not necessarily to set out that duty of care, but rather to inform what the duty of care looks like and to give normative weight to a responsibility on businesses to respect human rights. So I think while they are not binding, they do carry a large authoritative role in setting out what the standards are, and they do establish internationally what we expect of businesses towards human rights. There are 3 pillars to the guiding principles. The first is that the states have an ongoing duty to protect human rights that stems from their existing international human rights obligations. There is an extraterritorial impact to this. While that extraterritorial impact was debated at the time that the guiding principles were accepted or adopted by the Human Rights Council, several UN treaty bodies have clarified that states have an obligation to regulate the extraterritorial impacts of their corporate nationals. So if you are an EU business, the EU has a responsibility, or the EU member state that you're in has a responsibility to regulate your activities when they impact on the rights of Palestinians in Israel. I say that it's a responsibility to regulate. The guiding principles initially talked about a smart mix, a combination of compulsory and non-compulsory measures that are aimed to encourage businesses to respect human rights. But Germany gave us the largest real-life experiment in international law that we, I think, have ever had, when it tried to say that it didn't necessarily need to regulate its businesses to ensure they respected human rights, that they could just encourage them to think about how much they care about human rights, and they would adopt good due diligence processes, and everyone would live in harmony. And if you have not caught the sarcasm in my comments there, it didn't work. Between 13 and 19% of German businesses adopted appropriate due diligence over the next 4 years. And so Germany has been forced into a position, because it said that it would regulate if its businesses didn't meet their responsibility to respect human rights. It's now been forced into the position of doing that regulation, because they believed that if they just hoped that capitalist organizations would be good for human rights, that it would work, and it didn't. So now the claim that there's a duty to regulate, that it has to be binding, has been strengthened, and there's a burden of proof on states now to defend a decision not to regulate. So that binding implementation of the guiding principles through domestic law will start to take off more in coming years. So what is this business responsibility to respect human rights? Because that's the second pillar of the guiding principles, and it's where it made the most innovative contribution to international law. So the business responsibility to respect says that businesses should refrain from harming human rights in all of their activities, operations, or via their products. To do this, they're expected to conduct human rights due diligence, which assesses their real and potential risks that they pose, both directly through their operations, products, and goods, and indirectly through their global value chains and other business relationships. They should be undertaking a mapping exercise of this from a victims' rights approach, so that they're looking at the impact that they have on victims' rights, rather than simply the impact that they have on their own financial standing. They should be doing this in consultation with stakeholders, and particularly with directly affected rights holders. Once they undertake that mapping exercise, they are expected to develop mitigation plans. And if they have caused or contributed to a harm, terms I will return to in a second, they're expected to provide reparations and to cease the harmful conduct. If they're only directly linked to the harm, they're expected to use their leverage to affect change in their business partners. Again, I'm going to return to cause, contribute, and directly linked to in a moment. In conflict-affected areas, which is actually quite broadly defined, but obviously Israel and Palestine fit, that human rights due diligence is supposed to add a layer of heightened human rights due diligence. And according to the UN Working Group on Business and Human Rights, that includes not just understanding direct and indirect impacts, but also having a conflict-sensitive lens in which you look at the dynamics and the way in which you affect the actors to the conflict. So this requires businesses to understand how they sustain and promote violence through their activities. And it's this that gives the greatest possibility for using the UNGPs to advance Shahd's vision. Because a conflict-sensitive lens has to look not just at, are you directly contributing to an individual harm, but are you actually supporting, affecting, changing the way in which the Israeli government is able to affect harms? As I said before, where a business causes or contributes to a harm, they are required to change their behavior to stop the harmful conduct and to provide remedies to the victims. Where they're only directly linked to, they need to use their leverage to affect change. Traditionally, it's been assumed that contributions via taxation can only ever be directly linked to, that businesses don't incur responsibility to provide remedies or to change their behavior simply because they engage in taxation or they pay taxes. In 2022, in relationship to Russia and Ukraine, I started to reevaluate this assumption, and I'm drawing on that reevaluation here, that the resulting work will come out shortly. For cause, contribute, and directly linked to, there are 5 factors that matter. The first is the power of the business to affect the harm, either directly, via its relationship, or via its control over the environment. The independence of the business, either over the harm, over the commission of the harm itself, or over its own participation in that harm. So there's a bigger responsibility on transnational corporations than there are on businesses that are domesticated in a authoritarian state or in a problematic state. The severity of the harm matters, the predictability of the harm matters, and the business's effort to use mitigation measures, which includes using its leverage. Applying that to businesses in Israel's economy becomes quite simple. Transnational corporations have a great deal of power because they get to choose where they operate. They are not bound to operate within Israel. They can choose to terminate the relationship. They also have a great deal of independence specifically for that, because they can choose to leave. I promise to be like 1 more minute, Wissam. I promise. I'm sorry, I'm almost done. Severity, we're talking about 3 use cogent norm violations, as Shahd set out. We're also talking about genocide or accusations of genocide, credible violations of the Genocide Convention, according to the ICJ. And when it comes to predictability, we've already heard about how there are systemic and structural approaches and policies that mean that there is not going to be a change unless we see a significant change in the Israeli government. And then finally, mitigation measures. This is where effective leverage can be used, but the failure to use effective leverage moves a business from directly linked to contribution. And here, I think the question is, can you even have effective leverage in a context like Israel, where you have decades of systemic and structural violations and policies and practices that survive not 1 or 2 administrations, but again, multiple different parties, every governing body? And in that circumstance, I think the answer is no. There's no such thing as an ability to have mitigation. There's no ability to use leverage effectively in that context, which means that transnational corporations in particular that have the power and the independence to leave, that know about the severity of the harm and the predictability of the harm, become responsible by continuing to operate within Israel, just as they would become responsible if they continue to operate in Russia following the invasion of Ukraine. In a situation like that, businesses have to change their behavior and figure out a way to provide reparations and remedies. That's going to require consultation with stakeholders on the ground in Palestine, and it's going to require something that is much more comprehensive than what we see currently in reparations programs between businesses and individuals who are harmed, because you are talking about structural and systemic violations. Now I'm done. I'm sorry, Wissam.
No problem, Tara. Thank you very much. And thank you to all the panelists. I mean, this has been a very enriching and intellectually stimulating discussion with a lot to unpack. And I think it's a testament to the times that we are in and the challenges that we are facing. The genocide that we have been watching play out on our screens, the frustration of the lack of movement of the international system, forces us to find new and innovative ways to challenge this injustice. And I think peeling back these layers of the international economic system and how Israel's colonial practices have evolved over time to continue what I call this best business practice of colonialism, taking advantage of the developments in international economic law and neoliberal economic policies to further entrench its own colonization of Palestine, but to connect it with others, and thereby creating this incentive structure that makes it even more challenging for other states to disentangle themselves. But our responsibility is to identify where these links are and to push them to the greatest extent possible. So I think this session, thank you very much, Shahd, for initiating it, and Law for Palestine for bringing it to everyone's attention, because I think it is really a manifestation of necessity being the mother of invention. And we need this kind of thinking, exploring maybe those in the US might get this phrase, the rich man's international law, and knowing how to make use of these areas of law that we might not be accustomed to using as human rights advocates, but is incumbent upon us to start learning how to use them. And the panelists today have given us a lot of food for thought to dig deeper and do our own research and find more and more creative ways to challenge the continued injustice facing the Palestinian people. So thank you very much for that. We do have, luckily, some time for questions. And so I will go through the questions that you've all seen on your screen as well. Some have been answered, but I'll start in the order in which they've been received. The first one is, can you please elaborate on exploitation of natural resources within the context of de facto annexation and the role of third states towards the annexed territories and corporate dealings forthwith? That's the first question, and I'll read a second one and then give the panelists an opportunity to assess which one they want to answer, if any, and then I'll go to the next questions. The second question is, where there are no bilateral agreements, how can private investors be made accountable? So I'll pause there with those first two questions to see if anyone wants to take them. If not, then these are questions for further research as well. Tara, go ahead.
Sure, I'll get us started. So under the advisory opinion and more generally under international law, their de facto annexation is illegal. So the exploitation of natural resources that take place via that unlawful annexation are themselves unlawful. So the role of third-party states becomes quite easy. The International Court of Justice has consistently, not just in this advisory opinion and not just in the Palestinian Wall advisory opinion, but consistently has said that where there is unlawful activity, it is incumbent on third-party states to exercise their influence and their powers to bring about an end to that. You also have, not as explicit in the International Court of Justice decision or advisory opinion this time, although a little bit, you have under the Fourth Geneva Convention an ongoing obligation on third-party states to ensure that the parties to the conflict, which includes the occupying force, respect international humanitarian law, which means the protection of natural resources for the population to whom those natural resources belong, which is the occupied population. So the role of third-party states in that situation is to ensure that their companies are not involved in the illegal annexation and that they're not involved in the unlawful exploitation of natural resources. They have a duty, again, to regulate, but also to use their influence to bring about an end and to provide remedies and reparations to victims and to ensure that their courts are available for that. So those obligations are not developments from the UN guiding principles. They are actually existing binding international law on states that stem from the Genocide Convention, or sorry, also the Genocide Convention, but I meant the Geneva Conventions, as well as international human rights law treaties, as well as the UN Charter. So those ongoing obligations exist there.
Thank you, Tara. Does anyone else want to step in? If not, I can go to the next two questions.
I could
Yeah.
just simply in relation to the exploitation of natural resources, of course, as distinctly elaborated by Al-Haq throughout years of documentation in relation to that. That's one area, let's say, where there's a very clear international obligation not to recognize any extraction of natural resources. So, for example, the Dead Sea related products and the like. And the advisory opinion, as illustrated by Tara, gave us great content or affirmation, let's say, of the years of research into this subject matter. So indeed, it is simply as it stands, and it is quite unfortunate that we even still see these things entering the global value chain.
Thank you, Shahd. So the next two questions are more maybe general questions. One relates to the UN guiding principles and asks if these guiding principles are a mechanism only for states to use to regulate corporate activity, or can civil society use that as a tool to force corporate changing corporate behavior to be responsible and comply with international law? And the other question is regard to the WTO agreements. If countries don't comply with those agreements, what do they expose themselves to?
Yeah, maybe I'll pitch in on these issues, and also all respect to what Tara had shared on the UNGPs. Taking from where she landed, I would say that it's important as civil society groups as well to kind of question how some of the businesses involved with or in Israel use the guiding principles procedure in order to hide behind the complexity and the notions of undertaking the due diligence and then exercising leverage where possible and all of that, which is basically from our opinion, and also I think aligns with Tara's analysis, is irrelevant in this case. And if actually businesses are allowed to hide behind these procedures instead of terminating the relationship, that could contribute to the impunity and could contribute as well to a normalized relation that Israel benefits from in order to maintain its illegality. So in this sense, we have been calling on the relevant authoritative bodies pertaining to the UN guiding principles, such as the UN Working Group on Business and Human Rights, to provide clarifications on how the guiding principles ought to be approached, particularly in this case, to avoid these kind of exploitation of the complexity of the procedure. Now, when it comes to the requirements from business, they do stand independently of whether the state fulfills of its obligations under as affirmed by the guiding principles. So basically, if a state does not take action to tell its business through a legislative or an executive order or other administrative order that they are not to be involved in Israel or with Israel, still the business can be questioned in relation to what it did in or with Israel. And here I think the role of civil society becomes very important. Just to refer to the trade and investment issues, I wanted to close by saying, and I didn't get the chance, that in assessing the importance of breaking, suspending, or terminating trade and investment relations with Israel, the assessment ought not to be limited to the commercial aspect or, how much trade would stop with Israel in terms of import-export, or how much investment will be derailed or swayed away from Israel, because the value of these action is more political rather than strictly quantified from a trade and investment perspective. And this is why I think the history of the practice that was clarified by the General Assembly that normalized trade and investment relation contribute to sustaining the defiance of international law and the international community is very important in the case of Israel. Thank you.
Can I just come in briefly with some?
Yeah, go
Largely to say, I agree with Kinda that there is a lot of what we call greenwashing, where businesses use the guiding principles and the human rights due diligence process and the reporting mechanisms to suggest that everything is fine in their operations, and to suggest there's complexity in the Israel case that there isn't. So you hear about non-discrimination on the basis of religious grounds for illegal settlers, which is not a real thing, right? It's not their religion that's being challenged. When you're leaving an illegal settlement, you're ceasing to participate in a war crime. So it's an ongoing obligation. I will point to a piece that Jonathan Coley did for the Israel Law Review on the Unilever Ben & Jerry's case, where Ben & Jerry's chose to leave, and Unilever came in and said, no, it's complicated, we're going to stay. And the reality of that is Unilever used to be, and prior to this incident, was largely viewed as mostly a BHR, a business and human rights champion. We don't really, let's start with the fact that we don't have businesses that comply with the guiding principles. Like, full stop, I don't know of any business that truly, that's a stretch. I know of maybe 5 businesses that truly comply with the guiding principles globally. But Unilever used to be one that claimed to be a champion. And then you saw in this incident that as soon as it became economically complicated for them, not from a human rights perspective, not from a law perspective, but an economically complicated situation for them, that's when you saw them sacrifice human rights for their own financial interest. And that's what we've consistently seen from businesses operating in Palestine. And I'm going to say operating in Palestine because I mean the ones that are operating in the unlawful settlements in Palestinian territory. And that's a problem. And it's a problem that will only ever change when civil society starts holding businesses accountable. And so, yes, the guiding principles are principally about the state's responsibility in the first pillar and the business's responsibility in the second. But they are a tool that can be used to, as I started to say in the beginning of my comments, to influence the way in which we take domestic law and understand what a duty of care means for a business operating in a situation where you have systemic and structural war crimes. And I think once we start seeing more cases in domestic law, just using basic normal tort law and saying, actually, the guiding principles matter here, they should be informing the duty of care, then you're going to start to see a change in business practices.
Thank you, Tara. And I mean, we only have a few minutes left, but I did want to give a little bit of space to Mark, if you want to follow up on the issue of anti-boycott laws. Tara, you touched on it as well. I think the issue of challenging or pushing back against what we expect to be coming from the Trump administration. There's going to be, I'm sure, a lot of challenges that we need to navigate, and the anti-boycott laws are one of them. So maybe a few minutes to address it, if you like.
Sure, I can try. I have to just sort of preface by saying I'm not I haven't followed the laws closely. To my understanding, there's kind of 2 main mechanisms that have been used in these laws. One is basically to use contract, investment, public procurement as a way to create obligations on partners not to boycott Israel, and that this is used a lot in the US. And the second is laws that literally target those who call for boycotts with criminal or administrative penalties, and we're seeing this a lot in different parts of Europe. Both, especially the latter, but both are frankly direct threats to attempts to generate the political will for states to impose sanctions. With respect to what I was talking about, but they're also direct threats to the entire business and human rights movement, which is what both Tara and Kinda were referring to, which is specifically based on the principle that you actually can discriminate in global value chains, that you can say, I'm not going to do business with that business because of their human rights record. And so they're direct. So my point I just wanted to make was that they're direct threats, not just to activism on the question of in defense of Palestinian rights, but also more broadly. And I think we need to recognize that there's, this is coming. Well, I agree with you, Wissam. You referred to kind of the arrival of the Trump administration, and I don't think there's any question that this is not an administration that is in favor of ethical values and global value chains, that's going to be pursuing those issues, and that they have many allies in Europe and elsewhere. We're not in particularly favorable times, to put it bluntly, but we are also in a time in which millions of people over the past year took to the streets globally to defend Palestinian rights and to oppose racism against Palestinians and Jews worldwide, and so that there is a groundswell here. The trick is, how do we build this movement? How do we capitalize on the norms that we have to ensure that that movement is able to bring power to bear against the elites that want to try and undermine these norms? We're going to need allies. And I just want to point out that on the specific issue of sanctions against Israeli perpetrators or against Israel, we need to be looking for those allies in the places where there have been really strong advances and lessons learned in the sanctions space. And that is Ukraine with respect to Russian aggression, and it's Syria with respect to the Assad regime. Both of those communities have a long experience with how sanctions can work in a progressive context, and we should be looking to build allies partly for that reason, but also just because of the threat of the pushback that we're facing.
Thank you very much for that, Mark. And I know we have a hard stop at 1:30, so I just wanted to take a final minute to again express my gratitude personally for the opportunity to join and moderate this amazing panel. It's been a privilege and an honor. Thank you very much for Jurists for Palestine Forum, Law for Palestine, the ETO Consortium, and the Independent Commission for Human Rights for helping put this together, and for the brilliant minds that have shared their knowledge with us, which empowers us to continue moving forward. And all of those people standing for Palestine are also going to benefit from this knowledge. And it is incumbent upon us to carry this forward and put it to action. So that is the next step for us. And I wish you all a good evening, a good day, and I hope that we will meet again in person in a free Palestine soon. Thank you very much again for the opportunity.
Before we leave, just a second, just noting that what has been shared today will be published in separate policy reports, so that those will be shared either on Al-Haq's website or Law for Palestine, or at least summaries of those. So for those looking for further information, please stay tuned in, and further information to support your knowledge will become available. Sorry, Wissam.
No problem. Thank you, Shahd. Thanks for the vision to put this together as well. Thank you.